Good morning, everyone.
Good morning.
This is Richard Barra.
I'm Ashley Van Tol. I'm stepping in for Ms. Plimpton while she's on vacation.
Oh, another vacation?
Hey, a well-earned one with her kids, okay?
Hey, I am going to be going on a vacation in a couple of weeks. That's why I'm razzing her.
I love it. I love it.
Nice to meet you, Ashley.
Pleasure to meet you as well.
So, where is she going?
She is going to Cancun.
Oh, how
So
nice.
I
Now,
know
where
it.
was she said she was abroad a couple of weeks ago. So, where was that?
Oh, that's a good question. I think she was in Spain.
Oh, that's where I'm heading. I'm heading to Barcelona.
Oh my goodness, incredible. Well, enjoy.
Thank you. I hope to. I need it. I mean, this has not been a good year for me. My
Oh,
favorite horse that I've had for 32 years died in February. And then my favorite car, my Challenger, got demolished by a drunk driver while I was parked helping my friend who was dying of cancer. And then he went and died. He was my friend for 44 years. So that's a three-time hit in
oh.
a year. So I think I am entitled to a couple of weeks off.
I think you are correct. I'm very sorry to hear that.
It's been rough, but I mean, I'm still here. So I guess, they say the Lord won't give you more than you can handle. So I guess so far that's correct because I'm still here. So, are you going to be taking care of the case for the whole time or just for while she's gone?
That's a good question. Probably just while she's gone, but you may see me
I hope
again.
to. I hope to, because I mean, I must admit, you all like it's like I don't get to know one of your attorneys, and there's another one on the case. It's been
Yep.
nice that you have so many to trade off on. It's just me, and when so I have to be here at everyone. So
I see. I see.
Good morning, Judge Farley.
good morning.
Oh, Mr. Valentine, how'd everything go with dropping off your daughter? Did you keep it together?
I did. My wife and I both kept it together, and it was a fairly clean getaway. Um, yeah,
Very good.
we drove her out and then arrived back home in style in the cab of a flatbed truck with our car on the back. But it was only 50 miles south of Denver, so AAA paid the towing fees.
What happened to your
Wow.
car?
We just dropped all the coolant in heavy traffic and um so yeah.
Ay, 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 ay.
That doesn't sound good. Well, where is she going to school?
She is going to school at the University of California at Santa Barbara and um we kind of can't, let's put it this way, that will be the best real estate she ever has in her life. Her
Yeah,
her dorm
yeah.
is literally right next to the ocean. So,
Well, good luck finding housing for her for
yes.
all the years after her freshman year. One of my oldest son's best friends went there, and it just sounded nuts, the housing
It's
situation there.
nuts. She's already looking for her sophomore year.
Yeah.
Yeah.
Yeah, and the cost is, I mean, there's, from what I
Yes.
understand, there's very little housing to start out with. And then to get it, it's stupidly expensive.
Stupid expensive. I know.
Yeah.
Higher education is kind of bonkers these days.
It is. It is. So I guess you won't be retiring anytime soon.
No, I'm here for at least 4 more years, Judge.
So I see, Miss Van Tol, you are shaking your head. Are you from California? Do you know did you go to school there?
I am from Southern California originally, and I did go to USC for undergrad. So,
All right.
yeah,
Very good.
very familiar with the cost of living out there.
Yeah. Yeah. And Santa Barbara is, it's way up there.
That's
Um,
right.
yeah. It's a beautiful place to visit, but, thankfully neither of my kids had any interest in going there.
My
So,
kid was only interested in going to California, so we were kind of doomed from the beginning.
well, my oldest had interest and got into Cal Poly SLO. And after going to there to visit, I very much wanted him to go there because I wanted to visit there more regularly. It's a really cool little town, university town, but he chose not to. So,
Yeah.
Where'd he go
oh,
instead?
he's up at Colorado State.
Okay, awesome.
Both of our kids just wanted to stay in Colorado. Ultimately, they love Colorado. They love everything it has to offer, and yeah, so it worked out for us.
Nice.
All right, so are we ready to go? I'm assuming we are. And
Yep.
Miss Boulay, are you ready?
I am ready.
And Miss Federico?
Yes, I am.
All right, great. So we're on the record in the Colorado Public Utilities Commission's proceeding number 25A-0202CP. My name is Connor Farley. I'm the administrative law judge assigned to this proceeding. It is approximately now 11:05 a.m. on October 10th, 2025, and this remote pre-hearing conference is being webcast. This remote pre-hearing conference was scheduled in decision number R25-0694-I dated September 25th, 2025. And I will take appearances now, starting with the applicant.
Good morning, everybody. Ashley Van Tol appearing on behalf of Emerald Express.
Thank you and welcome. And I'll turn next to alphabetically intervener Alpine Taxi / Limo Inc.
Good morning, Your Honor. Mark Valentine from the law firm of Keys and Fox on behalf of Alpine.
Good morning and welcome. And finally, I'll turn to, oh, I won't try to say all of this. I'll just call you Ski Town.
Good morning, Your Honor. My name is Richard Barra, B as in boy, ARA, registration number 7886, appearing here on behalf of NDW Enterprises LLC, DBA Ski Town Transportation.
Thank you for that, Mr. Barra, and welcome to you as well. So,
Thank you, Your Honor.
as far as I know, the purpose of this remote pre-hearing conference is twofold. I think one of them has already been taken care of, but the first is to address the motion in limine that Alpine Taxi filed, and I received and reviewed the response to the motion in limine filed by the applicant Emerald Express this morning. So I'd like to address that. And then secondly, to address the scheduling of the hearing. And why don't we start with the scheduling of the hearing first? And as I understand it, everybody agrees, everybody's available and willing to do this the first week of December, meaning December 1st through 5th, somewhere in that time period. Do I have that right? I see Ms. Van Tol shaking her head. Why don't you go ahead and just say on the record?
Yes, that's correct, Your Honor.
Okay, and Mr. Valentine, that works for you as well?
Yes, Your Honor.
And finally, Mr. Barra?
As we stated, Your Honor, my client would not be available that Monday the 1st, nor the Friday of that week, but Tuesday, Wednesday, and Thursday of that week, we are available.
All right, so the 2nd through the 4th.
Yes, Your Honor.
Okay. All right, so I'm going to endeavor to schedule it there. The reason why I put it that way is because as you all want to have the hearing in Steamboat, I have to find facilities in which to do that. And I have, I just don't know whether the facilities are available on the 2nd through 4th. I'm hopeful that they will be, but I'm going to contact my contacts there just to make sure in the event that the facilities that we'll use are not available, I will communicate back with you by email to let you know that, and we'll try to find an alternative time in which to do it. So that's the process. Just wanted to let you know that. And of course, Ms. Van Tol, you're probably aware of this, but going beyond I think the 3rd week in November with the hearing creates problems for the commission in complying with the statutory deadline. So Ms. Plimpton had indicated that your client is willing to waive the statutory deadline, which is permissible, in order to hold the hearing after that 3rd week in November. So number one, I just want to make sure that I have that correct. Is that correct, Ms. Van Tol?
That's my understanding, Your Honor.
Okay, so number two, what I would request is for you on behalf of your client to file a document in the docket, just stating that.
Okay.
So it's 100% clear on the record that the statutory deadline has been waived. So it sounds like you're willing to do that. Do I have that right, Ms. Van Tol?
Yes, Your Honor.
So I'm not going to give you a deadline, but if you could do that soon, I'm going to wait for that before I actually schedule the hearing. So please do it sooner rather than later, hopefully within the next, few days and business days. So hopefully by the mid next week would be ideal for me. I'm going to, as soon as we get done, start the process of determining whether the facilities we're going to use are available December 2nd through 4th.
Understood.
Okay, great. So let's turn to the motion in limine. And let me just start at the end. We are some time away from the hearing at this point, so dealing with the motion in limine now is arguably atypical. But it does address a very distinct issue that may or may not be time sensitive. And what I mean by that is I wonder whether anything could change, and this is directed to you, Mr. Valentine, in between now and the beginning of the hearing, assuming that that takes place in early December, in terms of your client's ability to serve the airport.
Well, we certainly have been in negotiations with the airport, and there is a settlement offer that has been floated that is working its way through that process. I am waiting to hear back from my client on the offer the airport made to us. I don't know how it will be received, but if we do not manage to settle that case, or if the offer is thought to be sort of a non-starter, we're prepared to take other legal action by filing a petition with the commission.
Okay. All right.
And it echoes the strand of the motion that argues that the airport can't ban Alpine from serving its grounds. It can ban it from the building, but not from the airport, because the commission has issued its Cpcn, which requires Alpine to serve.
Okay, and I understand that argument. That argument is not and will not be before me in this proceeding.
That's correct.
So
But that,
so I
you asked what were, so I don't even know if the commission will accept that petition, and I don't know whether it would be handled with alacrity given the approaching ski season. I don't know any of those things, but that would be our attempt to clarify the legal issue.
Understood. Um, so, in your motion in limine, Mr. Valentine, you're basically asking me to preclude the presentation of any evidence regarding at least the current status of your
Well,
client with respect to providing transportation services to the airport. Do I have that right?
I think that's a fair characterization. I would argue, I guess I would say that it's more focused on the existence of the commercial dispute and the remedy that the airport has imposed.
Okay. Um, well, as the point was made in the response, of course.
Which I have not read yet, but yes.
Okay. Well, I'm sure this will not come as a surprise to you that one of the elements of the standard for proving uh, um, uh, that an application for a CPCN should be proven is the applicant has to show substantial inadequacy of the incumbent service. And that has been characterized over time in various decisions, including Colorado Supreme Court decisions, as well, an applicant to prove substantial inadequacy of the incumbent service can show that the incumbent is not ready, willing, and able to provide the transportation to anyone who might request it. Why? Well, it seems to me pretty clear, and the point was made in the response to your motion, that this evidence is relevant to whether your client is able to provide service to the airport. And since that's an element of proving up what they need to prove in order to obtain the application or have the application granted, why isn't that evidence relevant?
It's not relevant because it's not Alpine's ability. Alpine has the vehicles, Alpine has the drivers, Alpine has all of the elements in place needed to provide service. And substantial inadequacy has historically been related to a lot of things. It is a broad category, but it always has related to the ability of the carrier to provide the service. If you look at the witness and exhibit list provided by Emerald, it doesn't even talk about any of that. It talks about the airport wanting a new carrier in because it has prevented Alpine from serving, even though Alpine has everything it needs to serve. It's not Alpine's conduct that's at issue in terms of its service. We have a commercial dispute, that's true. They haven't filed a lawsuit. They haven't done anything to us except unilaterally decide that we're in breach. And so, I mean, it's a little bit of a catch-22. It's a circle that apparently, is designed to work in their favor. They bar us from the airport, then they say there's not sufficient providers, so we need a new provider. And they get, I mean, almost by definition, they get their way. That can't be the standard.
Okay. I think I understand. Let me just raise one other issue as well. One thing that an applicant also has to show is their own managerial fitness. Um, uh, is there any argument that the managerial fitness of an incumbent is a relevant consideration in one of these application cases?
Well, I guess what I would say is that the existence of a commercial dispute, you know, isn't dispositive as to the managerial fitness. I think that Alpine certainly isn't entitled to protect its financial status. And if that means there's a lawsuit, there's a lawsuit. If it means it's arbitration, it's arbitration. I mean, the other thing I would say is that it's not Alpine's managerial fitness that's at issue in the case. That's not the standard. They have the burden of proof to show managerial and operational and financial fitness. They don't have to, I suppose that managerial fitness would be relevant to showing that our service is substantially inadequate, but that's a tenuous connection. You have to actually show that the service itself is substantially inadequate. And there's nothing in their witness and exhibit list from a witness that he's even going to talk about that.
Okay. All right. I think I understand. Ms. Van Tol, do you have any response that you'd like to provide at this point? First of all, let me just ask you, did I accurately, at least at a general level, characterize the response that you filed this morning?
Yes, Your Honor. And I do have additional points in response. I would say in regards to Mr. Valentine's first argument, we cite in our response pretty recent Colorado Supreme Court precedent, and the law is clear. We have to show that the carrier is not ready, willing, and able. And that word able is clear to us. It's not necessarily that their vehicles are breaking down or they're unable to fulfill their service, but it includes extraneous factors, whatever that may be. And my understanding is that that's the present state of the law. And so to the extent that Mr. Valentine argues that there's some extraneous factor, well, according to the law, that is incredibly relevant to this analysis, and that should be admissible here.
Yeah, and I think Mr. Valentine disagrees with you on that. He thinks the able part of the ready, willing, and able just applies specifically to his client on whether they are able, if called upon, to provide the service. And his point is that they are, that a third party taking action to preclude them from being able to provide that service is not relevant to this test that you and I have both referred to. Sounds like you both have a disagreement over that. And are you aware of any case law that supports your position, Ms. Van Tol?
Not at this time, Your Honor.
Okay. All right. Thank you.
And
I think,
Judge,
you know what? Go ahead, Mr.
can I just add one thing? We're in a
Your
very
motion, so go ahead.
Yeah, thank you, Your Honor. One of the conundrums that Alpine faces right now is that it has reservations from passengers to provide service under its commission-issued Cpcn. And now the airport is basically stating, you can't do that. It's not the commission that's saying it. It's the airport. And this is a commission-issued Cpcn, and common carrier regulation is preemptive of a municipal regulation. This isn't some sort of municipal transportation system that's at issue here. And so what are we to do?
And I cannot give legal advice, so I'm not going to.
Well, I know it's
try.
a rhetorical question, Your Honor.
Right.
But we did argue that in our motion that the applicant wants to put on testimony from a third party that's taken an action that it's not legally allowed to do. And, you know, the commission is now being put in a very, very awkward spot. So what really matters is Alpine service and what the commission does. The commission should assume that Alpine can continue to serve the airport until it orders otherwise.
So what has the airport said about what would happen if your client showed up to pick up passengers who have reservations?
The airport has indicated that it will not allow Alpine to serve.
Okay.
And, you know, whether they've not been thoroughly transparent as far as to whether that includes the buildings, its concession stand. The airport contract at issue was for a concession. It was for a counter inside the airport. That's what the contract was for. But we are assuming that the airport won't allow Alpine to serve, period.
Okay. All right. Well, what I'm going to do with this at this point is I'm going to hold this in abeyance, and I am going to schedule a remote pre-hearing conference for about a week, maybe a little bit further out from when the hearing is going to take place. That remote pre-hearing conference is going to serve two purposes. One will be just to make sure that you all are all ready before I drive up to Steamboat to hold this hearing. I don't want to get up there and find out that somebody's asking for a continuance, particularly during snow season. So the first purpose of the remote pre-hearing conference, it will be scheduled a week or two before the actual hearing, is just to make sure everybody's ready and address any last minute issues. Number two, we'll come back to the motion in limine, and I will take oral argument at that time, further oral argument on it, and make a decision on the motion in limine either at that remote pre-hearing conference or soon thereafter. This will also allow us to get an update from Mr. Valentine on behalf of his client about where things stand, which could make the motion in limine moot. So that's my plan. Does anybody have any issue with that plan? I'll start with
No,
you,
Your
Ms.
Honor.
Mantle.
No,
Okay,
Your Honor.
thank you.
No, Your
All
Honor.
right.
Thank you.
Okay. So as I said, I'm going to go forward and attempt to schedule a hearing for sometime during December 2nd through 4th. I'm probably going to schedule it for 2 days unless I hear otherwise from you now about how long you think we need. So does anybody think we need longer than 2 days? Should I schedule it for all 3 days during that window? Does anybody think we need 3 days? I'm not seeing anybody jump forward. So, okay, my plan is to schedule it for 2 days. Hopefully we can get it done in one. But I think it would be wise to schedule it for 2 just in case. So that's my plan. And you'll see an interim decision after I get information regarding available dates at the facility that we're going to use in Steamboat. So with that, does anybody have anything further that they'd like me to address here today? I'll start with you, Ms. Van Tol.
No, Your Honor. Thank you.
And Mr. Barra, anything?
No, Your Honor. Thank you.
Thank you. And Mr. Valentine?
No, Your Honor. Thank you.
Okay, thank you all very much, and I wish you a good day and a good weekend. And at a minimum, I guess I'll see you at the remote pre-hearing conference that I'm going to schedule for a week or two before the hearing. Thank you very much.
Thank you.
We're adjourned.
Thank you, Your Honor.
Mm.